the state of Michigan versus Angelina Ann Hall, file number 25-22152FH. Ms. Hall is represented by Rhonda Underwood. This is the date and time set for sentencing on a probation violation. Ms. Underwood, I think I asked previously, but do you need to speak with Ms. Hall, or have you already done so?
I have already done so, Your Honor.
All right, so Ms. Hall, have you had a chance to read and review the probation violation report?
Yes, ma'am, I have.
All right, and have you had an opportunity to speak with Ms. Underwood?
Yes, I have.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
All right. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
We do not, Your Honor.
All right, before the court passes a sentence in this case, is there anything you'd like to say on behalf of Ms. Hall?
Yes, Your Honor. Ms. Hall, Your Honor, understands that the opportunity she had to complete recovery court expired with her being away so long, Your Honor. Ms. Hall freely admits she is in a situation where she needs intensive treatment, and more importantly, Your Honor, she needs to be away from this area. She really does. Ms. Hall welcomes the opportunity she's being given to complete the program at Bear River. She hopes that it contains transitional housing and the type of aftercare she really wants to lean into when she's done, Your Honor. And we find the recommendation appropriate, and we would ask the court to follow it.
Okay, thank you. Ms. Hall, is there anything you'd like to say on your own behalf?
Yes, just that I'm grateful I'm grateful for Miss Tess, honestly. She's honestly gave me another opportunity to try again and hope that.
This is one of those moments judges listen for carefully, not excuses, but accountability. Miss Hall admitting she needs to leave her environment shows how recovery cases are often about changing people, places, and habits all at once. Do you think a fresh start really helps break addiction cycles?
I don't know nothing about Bear Rivers. I've never been anywhere outside Adrian or Toledo, Ohio. So this is a long drive for me, but I'm just ready to be away from all this crap, honestly, and tired of being sick and tired.
And so she understands that it's on her. There's going to be no backup to this. She is going to have to complete and police herself. And I think as long as she stays up there and does that, she may turn this around.
Yes, ma'am. Thank you.
All right. So, Ms. Hall, obviously, you've been through recovery court, and you had that foundation before. Addiction is a horrible thing, and I don't claim to ever understand it because, I've seen what you've gone through. I've seen how hard you work to maintain sobriety, but, you never stop trying, right?
Yes, ma'am.
All right.
Huge turning point here. The judge revokes probation, but still leaves the door open for treatment instead of pure punishment. That's the balancing act in recovery court. Consequences on one side, rehabilitation on the other. One wrong move now, and that second chance disappears instantly.
Thank you. So it is the sentence of the court that I will revoke your probation. I'll order that you serve 1 year in the Lenawee County Jail I'll give you credit for 132 days already served, and then I will allow you to be released to Bear River Residential Treatment. Understand, if you take off, we will issue a warrant, right? Is that how it works?
She won't.
No.
Be on probation.
Oh, so Ms. Hall, I mean, at this point, you know, if you go to Bear River, you've been to residential treatment, you've been through programming, take advantage of it, you know, stick it out, you know, find a better place. And if it means move, because sometimes people, places and things bring you down. So I'll give you credit for the 132 days. I wish you the very best of luck. And I know that you can do this. So we'll send over your advice of rights. They'll give you 3 copies, one for you to date and sign, the other copies, and they'll return that to us so that we know you got it. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the forms and mail it to the address listed on the form. What Ms. Teskey just said is basically, if you don't finish Bear River, that's on you. There's nothing we can do about it, but at least you're getting this opportunity. All right.
So yes, so I can be released whenever their bed is ready, is what's that saying? Yeah. Okay.
Yep.
All right. That's a long ways away. All right. Thank you so much.
Is this something we put Emily on, Your Honor? Ms. Teskey?
I'll make the referral, Rhonda, and work with Tamara, the program coordinator at the jail.
So Ms. Teskey makes the referral and she'll work with the coordinator at the jail to get her there.
Okay.
Thank you.
Okay. Thank you.
Very much. Have a good
Good luck, Ms. Hall. Thank you. Okay. So now we're back to Mr. Cousineau. Ms. Underwood, you said you need to talk to him again?
There
No?
is either a 4-year or a 5-year. The 4-year.
Are you talking to me or to Cody Cousineau?
Ms. McClure, what is the 5-year? I know the 4-year is a controlled substance use. Or
no, the 4-year would be a possession of a controlled substance, another narcotic. The
right.
5 years an attempt possession of meth.
Oh.
Attempted would be a lower grid, right?
I think they're this. It might be. I think they're the same though on this one. They're both E-grid.
You haven't been here in forever. Where have you been? We missed you.
Or both of the new case. Oh. Yeah, but it's late more.
Miss Underwood, are you going to need a few minutes and a chance to talk to your client?
I think the attempt would be an H grid, and the possession would be a G grid. If I'm right.
Well, attempts are always an H grid, right?
No, I think they just go down one. So the possession of another narcotic is a G grid, so she's correct on that. The attempt is an E grid. Yeah, it just goes down one.
So, Miss Underwood, let me go over to Mr. Okay.
Just let me know and I'll do the amended, or we can put it over till Wednesday. And
no, we can't. I've got like 200 pre-trials and arraignments.
Oh, but I mean, as arraignments on Wednesday, that's all.
Yeah, but we can do it today though. I'd rather do it today.
Yeah.
So Miss Underwood, she said the attempt goes down to an E grid.
Is the, I'm sorry, Ms. What is the grid on the original charge?
D.
D?
D.
Yeah,
D.
Possession of meth, D.
Those go down to H's.
Okay,
Almost.
So why don't you, Miss Underwood, go through the guidelines and look it up or something, and let me take Mr. Amadeo's case, because Yeah,
Okay,
it'll go real quick. So why don't
Give me a
you want to
second.
break out? Okay,
I'm gonna just go with the guidelines.
okay.
I mean, I just looked in the book. We can trust the book. It goes
Yeah,
to
I'm gonna go on to Mr. Amadeo's case. Mr. Amadeo,
Good morning, Judge. How are you?
I am good. So hold on one second. All right, Mr. Lambert, can you hear me?
Yeah, we didn't do it this time. It was him.
I don't know where I'm getting all the notes. Oh, Mr. Lambert, go ahead and unmute your device.
I finished, I put in words, we got it all together, you know.
Hello? Hear me now?
Yep, I can. Why don't you take your hat off?
Okay.
So let's see the flag.
All right, Mr. Amadeo, is there any way you can walk somewhere where we're not getting that voice in the background because it's kind of messing with our recording?
Yes, I'm sorry, Judge. We moved to a different
It's
part of the court.
okay. Where are you at?
I'm in Washington District.
Yeah.
Is that a little better?
Yeah, perfect. Okay, so this is in the matter of the people of the state of Michigan versus Randall Allen Lambert. File number 26-22513FH. I have Mr. William Amadeo appearing on behalf of Mr. Lambert. And I have Phoebe McClure appearing on behalf of the people. This is the date and time set for sentencing in this matter. Mr. Lambert, have you had a chance to go through the pre-sentence report and read and review it?
Yes, Your Honor.
Have you had an opportunity to speak with Mr. Amadeo about it?
Yes, Your Honor.
Are you satisfied with Mr. Amadeo as your attorney and the advice that he has given you?
Yes, Your Honor.
All right, Mr. Amadeo or Ms. McClure, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Mr. Amadeo?
No additions, deletions, or corrections at all, Your Honor. Thank you.
All right, does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Ms. McClure?
No, Your Honor.
Mr. Amadeo?
No, Your Honor.
All right, the probation department has computed the minimum sentencing guidelines to be 2 to 17 months. Do you agree with that computation guidelines, Ms. McClure?
Yes, Your Honor.
Mr. Amadeo?
I do, Your Honor.
All right, Ms. McClure, before the court passes sentence, is there anything you'd like to say on behalf of the people?
Just briefly, Ms. Faye, can you hear me okay right here?
Yes.
Okay.
Thank you.
Just briefly, Your Honor, in this case, Mr. Lambert and Ms. Ellis have a long history that was pretty tumultuous. Just for the court's edification, there was a domestic violence that they had together in January of 2025 that was dismissed. And then they made it all the way until December of that year before they got another one, or he got another one on her. And then there was our present case, which was a violation of bond on the December 2025 case. There was an alleged strangulation in this case. We did dismiss that with a plea to the felonious assault, as well as a plea to that original DV, the December 2025 one. So he did plead to that in district court, or is going to if he hasn't yet. I believe he has pled to that. So we did take responsibility for these. Obviously, we would like them to have no contact, but I think just given the fact that this case was a violation of bond in the December case, so they are, there was some escalation between them. We did make an agreement that there would be no further initial incarceration, and I do stand by that. But I would ask the court to impose an extra 30 days, so 60 days total with credit for 25 days. And that balance be suspended if there's any violation between the two of them, or another assaultive violation. So that's what I would ask for. Otherwise, I would ask the court to follow the recommendation.
Okay, thank you.
Thank you.
Hold on, Mr. Amadeo is trying to go somewhere quiet.
I'm good, Judge.
Okay, all right, so Mr. Amadeo, is there anything you'd like to say on behalf of Mr. Lambert?
Your Honor, I do feel this was a defendable case, but he did take responsibility. He didn't play any games with the system. He waived his prelim. He has pled in district court. He's being sentenced on the DV. on April 10th before Judge Shagler. He served 25 days in jail. I do think the request from APA McClure makes sense because that would be the bottom of the guidelines. We do have a Kilbur for no upfront jail. He's behaved well since I've been involved in this case. I hope they have no contact together ever again. I don't know how that will work because I do know there's a history and there's a family and such, but I think the relationship was toxic. I think he's learned from this. I think he's straightened his life out to the best he can. I ask that you follow the recommendation. Thank you.
Okay, very good. Mr. Lambert, is there anything you want to say on your own behalf?
No, thank you.
All right. Well, I appreciate the summary, Ms. McClure. Mr. Lambert was a member of our recovery court, and so I'm quite aware of the long history between this individual and Mr. Lambert.
And there it is, the court calling the relationship extremely toxic. In domestic violence cases, judges often look beyond one isolated incident and focus on repeated patterns. The warning couldn't be clearer. Continued contact could drag both parties right back into court.
So, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law, and the protection of society. Mr. Lambert, there have been times when we have told you to not take her calls. You know, this has been going back and forth. She does something, you do something. She does something, you do something. And I know in recovery court, I think Ms. Teskey and I both told you, you need to stay away from her because you two are extremely toxic. So I hope going forward, you can do that because this could have been really bad. Do you understand, Mr. Lambert?
Yes.
Okay, I'm going to place you on probation for a period of 2 years. During that term of probation, you must, there's no consumption of alcohol, no use of illegal controlled substances. You must take all medication as prescribed by your doctor. Complete any assessments, whether it's domestic violence, substance abuse, or alcohol as required by the probation department. Not to have any contact with Jennifer Ellis. Not written, not verbal, not text, not waving at her walking down the street. So if she contacts you, you need to call the police and report it so that you don't get in trouble. Do you understand that?
Yes, Your Honor.
All right, you can't use any object as a weapon. Probation department can enter your house, your car, your phone, your computer, anything else if they have reason to believe that you have violated your terms of probation. I am going to order the 60 days in jail with credit for 25 days served, and I will suspend the balance, okay?
Okay.
There is a $30. Are you still on SSI?
No, I'm not on SSI. I'm still working, Your Honor.
Oh, okay. I'm sorry. I thought you had gone on SSI. There's a $30 per month supervision fee, 60 if we have to put a tether on you, $750 in court costs, $130 crime victim rights fee, and $68 in state costs. So, Mr. Lambert, no more contact with her. Do you understand?
Okay.
Okay. I mean, you're here because of that. So, now, Mr. Lambert, we are going to mail to you your notice of right to appellate review. They're going to have you initial one copy. It'll be marked to initial one copy, or you can have them report Tuesday.
I'll have them report Monday at 8 a.m.
Do you think if we gave you the paperwork, you could just have them initial it?
Yeah, I can do that.
All right, so we'll give it to Mr. Stevenson, and then he'll have you just initial one copy, and he'll give you the other copies, and he'll get one copy back for us.
Okay.
Now, if you wish to appeal your sentence, you would fill out the paperwork and mail it to the, or drop it back off at the court within 42 days. You understand?
Yes.
And then oh, go ahead, Mr. Lambert.
No, go ahead, Don. No, I was just listening. I'm sorry. Yeah, I would just say you said I have to fill out a paper and then send it back in. I couldn't.
So what we're gonna have is your appellate rights in case you want to appeal my sentence. He's
Yeah.
gonna have you initial and date one, just so I know that you received the paperwork. The other two are for you. If you wish to appeal my sentence, then you would fill out the paperwork and hand it into the court, all right?
Okay.
All right, and now, Mr. Steve, 8 o'clock, you said?
Yes.
Mr. Stevenson wants to see you Monday morning at 8 o'clock. Do you understand?
Yes, Your Honor.
Got it. All right. Good luck to you, Mr. Lambert. Mr. Amadeo, thank you.
Thank you, Your Honor. Have a good day. Bye.
You too. You're all set, Mr. Lambert.
Thank you.
All right, Miss Underwood, are you ready on Kuzno?
Yes, Your Honor. Your Honor,
Getting the information right now.
Miss McClure is doing the information right now.
I'm emailing.
She's emailing the information right now.
Could you include me, please, Ms. McClure?
Yes.
And Miss Iddings, is Mr. Noe still on this case?
No, Your Honor. As far as I know, Ms. Kopke is representing herself. She did at the last several hearings as well as at the front of the court hearing.
And this is just a review?
Just a review, Your Honor, just to let you know what's going on.
All right. So while we're doing that, I'm going to do this